Welcome to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
I hope everyone enjoys our great new theme music, which was written and performed by Ali Arshi, a graduate of the Berklee School of Music in Boston. We have a great topic today. We're going to be discussing product by process claims. The case we'll be discussing today is Restem LLC versus Cell LLC. Cell is the owner of a patent drawn to stem cells, and Restem is a competitor. The case arises out of an inter-parties review proceeding, so we'll be discussing that very briefly. Then I'll get into the technology also briefly and take a look at the claims. Reza M will describe the claim limitations in some detail, and Reza S will bring us up to speed on legal requirements of product by process claims and inherency, which are relevant to this case. Of course, we'll finish up with the usual discussion of important aspects of this case and some lessons we can learn from it. So let's start by taking a look at the case, Restem LLC versus Cell LLC. And again, Cell is the patent owner and Restem is a competitor. Now, Restem challenged Cell's patent, which is number 9803176, asserting that the claims were unpatentable due to inherent anticipation or obviousness based on prior art. Restem contended that the prior art disclosed similar processes that would inevitably produce the claimed stem cells with the claimed cell surface markers, which we'll get into. So the Patent Trial and Appeal Board actually upheld the validity of Cell's 176 patent. Restem appealed the PTAB decision to the United States Court of Appeals for the Federal Circuit, which upheld the PTAB finding that the claims are valid. So just a brief discussion about inter-parties review proceedings generally, and then we'll get into the details in a little bit. So an IPR, or inter-parties review, is a proceeding conducted by the Patent Trial and Appeal Board to review the validity of a granted U.S. patent. Now, these are initiated by a third-party, so-called petitioner, challenging the claims as unpatentable. These are limited to challenges based on prior art, which consists of patents or printed publications, basically. And there's a couple possible outcomes of an inter-parties review proceeding. All the claims of the patent can be upheld, which is what happened here. So therefore, the patent remains essentially unchanged. Some claims can be invalidated, leaving other claims which are essentially canceled. All the claims could be invalidated, in which case the patent is essentially rendered unenforceable. And as here, the decision can be appealed to the Federal Circuit. We can discuss the technology a bit. So the technology in the 176 patent is directed to stem cells, also stem cell components, and particularly methods of generating and using stem cells. Disclosure provides for an isolated cell that is capable of self-renewal and expansion and is obtained from the subepithelial layer of a mammalian umbilical cord tissue. Variety of cells and cellular products can be derived from these isolated cells. For example, isolated exosomes, which can also be used for treatment, as well as differentiated cells such as adipocytes and chondrocytes, which make cartilage, osteocytes make bone, and cardiomyocytes, which of course are relevant for the heart. And these cellular treatments could be utilized to treat, for example, COPD, diabetes, ischemia, osteoarthritis, liver damage, angina, and et cetera. So if we look at the claim, and we're going to go into a bit more detail with specific claim limitations. Again, this is patent number 9803176. And it's an interesting claim, right? Because it's a product by process claim. So that means we're claiming the product, but we're going to set forth the process to make that product. So here we've got an isolated cell, and that's going to be important as we'll discuss in a bit, prepared by a process comprising, and we've only got two steps. We've got a placing step where we place a subepithelial layer of a mammalian umbilical cord tissue in direct contact with a growth substrate. And then there's a culturing step. So the subepithelial layer is cultured such that the isolated cell from the subepithelial layer is capable of self-renewal and culture expansion. Now we've got a couple of where-in clauses, which are important. And they set forth the profile of the isolated cells. So here we've got wherein the isolated cell expresses at least 3 cell markers, surface cell markers, and select from the group, and it's got this list here. And then we've also got a negative limitation wherein the isolated cell does not express ANOG and at least 5 cell markers, and it's got a list. Just briefly, the stem cells with the 3-cell markers are actually what are called mesenchymal stem cells. So they're not pluripotent stem cells, which can become any type of cell. They've already gone through at least one bit of differentiation, and now they're mesenchymal stem cells. So those can make the adipose tissue and the muscle tissue and other things that we discussed above. The negative limitations where the cell does not express NANOG, which is a transcription factor, and these other cell surface markers, those are more indicative of cells that have maintained pluripotency. That is, they can become any type of cell. So here we're claiming more slightly differentiated mesenchymal stem cells. I'm going to discuss what the specification teaches briefly. Here we've got only 2 steps, placing and culturing. Basically, the process is set forth in the specification is more, it goes into further detail, right? It isolates the umbilical cord, slice open the umbilical cord, you do a washing step, put it face down on so that is to say the inside of the umbilical cord is face down on the substrate layer, and it's incubated, and you can vary the oxygen levels during the incubation, and then you can go ahead and isolate the cells. I think this is going to be important as we kind of get into the inherent anticipation discussion briefly, but I think I'll turn it over to Reza M to go through the claim construction a little bit.
Thanks, Joe. So there were a few terms that were construed during this process of the challenge to this patent. One of them was the term placing. So, as Joe mentioned, one of the steps of the claim says placing a subepithelial layer of a mammalian umbilical cord tissue in direct contact with the growth substrate. And the way the board construed that limitation was to intentionally place umbilical cord tissue comprising the subepithelial layer so that it touches a growth substrate to permit cell culture. So that's the way it was construed by the board. There was basically an objection to that construction by the challenger, indicating that the board had to consider other limitations in that construction, in particular, which side of the subepithelial layer was placed in contact with the growth substrate. But CAFC basically agreed with the board construction and indicated that those other limitations were specific limitations of certain embodiments, and as a general matter, one should not import specific limitations of certain embodiments into claim construction. Then there was the construction of the term isolated cell. And here the board did not provide a very explicit construction of that, but nonetheless, the board construed another term in the claim, meaning the expressing or not expressing certain surface markers. And by construing that, essentially implicitly construed the term isolated cell, because the board indicated that essentially it determines whether, meaning expressing or not expressing a marker means whether the marker is present or absent in the cell. And both, I think the board and CAFC indicated that it is known that in order to do that, to determine whether the markers are present or not present, one looks at a population of cells. And so therefore they construed that as a population of cells. CAFC indicated that that construction was correct. And in fact, it looked into what happened during prosecution, including how the examiner had viewed that term. And they mentioned that the examiner, in fact, had viewed that term in terms of a population of cells. And in some sense, what had occurred during prosecution, given essentially credence to that particular construction. Now, the interesting thing here is that the patentee, in fact, had essentially construed that term, defined that term in the specification by saying that, and this is exactly what they say, as used herein, the term isolated cell refers to a cell that has been isolated from the subepithelial layer of a mammalian umbilical cord. So in a way, that definition seems to be perhaps inconsistent with the population of cells. Nonetheless, both the board and CAFC indicated what had happened during prosecution had provided essentially imposed that limitation that it really relates to the population of cells. And we have sort of in our previous video, we had talked about claim construction and how prosecution history can affect how a term is ultimately construed. And this is what happened also here as well. So I think at this point, I turn it over to Reza S. to talk about product by process claims in general and the issues of inherency that had come up in this case.
Thanks, Reza. So yes, let's talk about these two legal issues that came up in this case, in particular, type of claim, product by process, and the doctrine of inherency, both relevant. And to that point, let's look at the claim one more time, this time from the point of view of these two issues. As Joe presented it, we have a claim to an isolated cell, so it's a product claim. However, it's claimed, recited in terms of the process for making it, preparing it. And it has those two steps of placing and culturing, but also it has the additional limitations which come in the wherein phrases. In some sense, this is a type of product by process claim that I call a hybrid claim, product by process, because in addition to the steps, it includes those additional limitations about the characteristics of the product itself. And I'm going to touch upon that further. What happened here is that the challenger, Restem, argued the claim is anticipated, or at least obvious in light of prior art majority, which had disclosed those steps. And they added to that the additional limitations that were in part flows from it. And here is where they use the doctrine of inherency, to which I'm going to refer further and discuss. So let's start by product by process. As I said, I consider this kind of a hybrid because of the additional limitations. My colleagues here reminded me that very often where product by process claims are used, we do have the additional limitations. This is very common. And as we know, this type of claiming mostly happens in areas such as pharmaceuticals, bio type of claims, or even material science, where fully characterizing the product by its features may be difficult. And we can later go into why somebody goes and uses this type of claiming anyways, instead of just process. But the additional elements are there here. And I looked through the case law, search for pure, so-called pure product by process cases. And it was not easy, as they had told me. Most often we do have this type of claiming as is here, but I came across two of them at least. One is the Abbott Labs, a Federal Circuit 2009 Federal Circuit case. Here you see the claim at issue. As you see, the preamble talks about the crystalline, and it goes on, but the body says obtainable by acidifying a solution, so on and so forth, at room temperature under warming. One may say this is a pure product by process claim because the only limitation is a process step of acidifying. However, again, my colleagues pointed out that here the preamble may play a role and may be considered limiting. Another case I found was this case of In Re Thorpe, 1985 Federal Circuit. Here, the main claim at issue is a process claim, a method claim. That's claim 1, as you see. But then another claim at issue is claim 44, which says the product of the process of claim 1. I would say this claim 44 we may call a pure product by process claim. Now, why am I looking for this type of claims, or in general, even the hybrid ones? What's the law behind product by process claims? I've copied a section of MPP, section 2113, which lays down the law as it stands today. The point being that the product by process claim can be considered unpatentable. It can be anticipated by a prior art that essentially provides or results in the same product, even if they don't disclose the same steps, even if they use a different method. That's the law. It stands for anticipation or obviousness, essentially regarding patentability. But then when it goes to the stage of infringement, the patent owner should show that the infringed or the accused product not only is similar to the one that is claimed in terms of the product, but also that the accused infringer uses the same process. So in some sense, you can say on both ends is limiting towards the patent applicant or patent owner. That's the way I always remember the law. And I guess this is the policy behind this. That is the price you pay by claiming your product through its process. Now, as I said, what the challenger in this case said that the steps were in the prior art, and they stated even in the oral argument, it came again and again, it came up that because they follow the same steps, they should result in the same product. So those wherein clauses of the product also is implicit there. In other words, is inherent. And that brings us to the doctrine of inherency, which I'm going to present here by an example again from the case law. There's a case of Saitiva of 2024. As you can see, claim 1 is a chromatography matrix. So it's a product that with those features, a solid support, a ligand, and the wherein clauses. And then claim 4, which was also at issue, says the chromatography matrix of claim 1, wherein the ligand is capable of binding to the Fab part of an antibody, whatever that is. But essentially, it adds a limitation of that binding capability. And the court here deemed claim 1 obvious over a combination of prior art. But when they got to claim 4, they also said it is unpatentable over the same combination because there was evidence that the binding property that is recited in claim 4 naturally arises and therefore is inherent in the product recited in claim 1. And that's the doctrine of inherency, that even if the prior art doesn't explicitly mention or disclose the feature, in this case, the binding feature, if we can show that, if the challenger can show that, or the patent office, that the prior art naturally has those features, then it's not patentable. That claim is invalid. So going back to the claim for last time, the argument here was by Restem that the two steps are in prior art and the wherein clauses flow from that, but they couldn't prove it. They were pressed for it, and in fact, it was agreed that those are additional features that are not inherent in any product that is produced by the same process. There are additional features that require additional steps, which in fact, actually here the patentee discussed in the specification how to further provide those features. And that was why the challenger failed and the patent was upheld as patentable. So maybe it's a good time to go to some discussion about key takeaways of this case.
Well, people who watch our videos know that we talk about 101 and patentable subject matter all the time. And so the thing that jumped out at me at this claim, the isolated cell, with this cell surface marker profile, I thought, oh, this has got to be a 101 issue. Why aren't we discussing whether or not this is a natural product? And so I took a look at the prosecution history. So the prosecution history is the back and forth between the applicant and the examiner, the USPTO. And so you can, you read through it and you can see what the arguments are, and that can be helped to use to construe the claims. As Reza mentioned earlier, the court looked at the notice of allowance and the examiner's statement of reasons for allowance and actually construed that in a certain way to what isolated cells means. So there was a lot of prosecution for this application, went a few rounds or a couple of RCs and things like that. And 101 was a big issue. And I think reading the 101 is actually instructive as to possibly why the court found the way it did with inherency. And for this reason, the applicant, the inventor actually, put in a couple declarations. Basically, they showed that isolating these cells using different methods will lead to a different cell surface profile. You'll get different cells produced if you change the process. And so the process that they disclosed, and you can argue whether or not more should have been in the claim or not, but the process they disclosed of the slicing the umbilical cord open, cleaning it, putting it face down in a substrate, isolating the cells from that will lead to cells with a different cell surface marker profile, i.e. there will be different types of cells than either what's in the prior art or what's naturally occurring. So, my thought, like I said, when I looked at this claim, I thought, well, these cells naturally occur. The applicant, now patentee, presented evidence that that is not the case, that these cells will not occur naturally without doing this particular steps of the method that they disclosed.
So you're saying, Joe, that the 101 issue was raised during prosecution and
A lot.
the patentee was able to overcome it. So maybe
Yes.
that wasn't a good approach. But it's true that even if the challenger wanted to use that line of challenge, IPR wouldn't be the right vehicle, correct?
That is
Because they
correct,
can
yeah.
raise 101.
Right.
It would be a different way of approaching that, correct?
Yeah. And a little bit further on that, the method disclosed in the Majori reference is different. So in the Majori reference, you take umbilical cord, you mince it, and put it in a culture flask. And so therefore, it's not inherent that you're going to get the same cells. Applicant, the inventor, actually showed that if you vary the steps of producing the cells, will lead to a different outcome. Now, I don't think there was a side-by-side comparison of the two steps from Majori and the claimed method, but it did show that if you change the process steps, you will get a different result. So I wonder if the court knew that, took that into judicial notice of it or whatever, and thought, oh, okay, it's not inherent that if you just do these steps, you're getting these cells.
But one of the things that I think the challenger was saying was that if you are going to construe the claims broadly, in terms of, for example, the placing step was construed broadly, didn't require a particular way of putting the subepithelial layer, it's just, say, placing in contact with, then we have the prior art has those steps in terms of the way the steps were construed. But of course, that wasn't sufficient. Even if you say it has those two steps, they still needed to show that the cells had particular types of markers, and they couldn't show that. Now, what I wondered about was if the claim, rather than saying wherein, had recited the steps and said thereby these things have these properties, these cells have these properties, what would have happened in that situation? Presumably, of course, you still need to show that the products in general have those features, but I wonder whether or not in that kind of situation, on a summary judgment motion, one could have argued, or the challenger could have argued, that there was an admission by the patent owner that performing those steps would naturally flow to the cells having those particular surface markers. I just don't know, but I wonder whether the choice of what word to use would potentially matter in these type of situations.
The other thing, if they had used thereby, and I think that could have been done, I wonder if that would have raised an enablement issue, because the inventor below, during prosecution, shows that if you vary the steps of the method, you will end up with different cells with a different cell surface marker profiles, basically different types of cells. And if they had the thereby there, that might have necessitated them adding more steps or more clearly defining the method than just using these two steps and then having an enabling example.
Yeah.
I think that would open
them. They made the
up.
right choice here, wherein actually helped them in that sense.
Yeah, I think so.
But thereby wouldn't help. Yeah, wouldn't help
wouldn't
the
have helped
patentee
them as much.
on a relevant matter. On the same matter, on the relevant matter, this kind of was raised during the oral argument as well. And that is the challenger, their counsel did say that, look, prior art performs those steps, so it has to have those properties. And the court pressed them. They said, 100%? Can you say that? Can you prove that? And they couldn't. Of course, that's not true. And actually, again, on a relevant matter, enablement did come up too during the oral argument because they said, let's look at it. Here we have only two steps, rather broad, as Joe had mentioned. And is that enough to get those properties? How do you get those properties, essentially? It's not in the claim. And they said, yeah, we have explained it in the spec. There are extra steps, as was mentioned. So those extra properties come from those extra steps. And here's the lesson. You don't have to put that all in the claim. You've enabled it, it's in the spec, and they decided not to include those extra steps, and that would be fine.
One of the things that Joe mentioned in the 101 is interesting because after all, if the prior art didn't disclose the surface markers, in principle, one could say that they could have just claimed an isolated cell with those surface markers. Now the question is, why didn't they go that way? Perhaps, Joe, is because of 101 issues that they were concerned about those. That's why they took the product by process route, perhaps.
Yeah, I think so. And the other thing that's interesting to me, and I don't know that it really came up that much, but I think the limitation, direct contact with a gross substrate, particularly the gross substrate part of the claim, I think differentiates over the Maggiore reference because, as I mentioned, Maggiore, there's a mincing step and then you drop it into a flask and shake it. It gets on a shaker bath. That's significantly different than just taking a piece of tissue and laying it face down on, something that looks like a petri dish and incubating it. You're going to end up with different kinds of cells. And I think that's probably, I just wonder how much the court looked at what the inventor had argued or demonstrated rather, and said, okay, we've seen that if you do different steps, even seemingly slightly different steps, you end up with significantly different cells. And that was enough to save them both from the 101 issue which the examiner mentioned and from this Maggiore reference too. I can read it. I printed out the statement of reasons for allowance, and it's I think it's instructive. Applicant submission of an affidavit by Dr. Patel dated 6/21/17 establishes that the methods for isolating the claimed population produce a markedly different cell population than that of other methodologies. In other words, the methods of isolation cause different phenotypic and genotypic changes in the resultant cell populations. For at least this reason, and the reasons evident in the prosecution history, the present claims are found to be allowable. We see the part where the court relied on, methods for isolating the claimed population, which is interesting. But then it goes on to say that these methodologies, even relatively slight changes seemingly, lead to big differences in the cell population, enough to get them outside of 101 and presumably enough to get them outside of this Maggiore reference.
It's interesting because going back to what Reza was saying about patentability, even if they didn't have those steps, the prior art, as long as the cells, they could have shown that the cells had those limitations, they would have still been able to invalidate the claim. So that's kind of an interesting, difference between infringement and patentability.
I'm not sure if that's the case. Let me understand, because this is important. The point is that, yes, we have those additional limitations, the Warren limitation, but we also have the steps, and the steps probably change the characterization of the product as well. So they do something. It's not that what you have under Warren is all you have about the product.
I think that's all we have in this case.
I doubt it. I doubt it
because I think they could have shown that there is a reference that has those characteristics, unless.
But I'm sorry. I apologize for.
Yeah.
Let's understand, when you have a product by process claim, you have to analyze it so deeply to say through that process what product comes out, and
Yes.
then prove that product is in the prior art. The product is not just the wearing clauses. It's also what
But the way
comes
they
out
have
of the steps.
characterized the product, there was nothing that they said that could show that the product had other than those markers that would have been the result of the process.
I respectfully disagree.
As long as the reference had shown the isolated cell, they would have been done, I think. They would have invalidated the claim.
Well, I respectfully disagree. It's not my area, so somebody who's an expert should tell me. I'm assuming, and that's why I showed the pure product by process claims. I'm assuming the first two steps do things, and then there is additional steps that they didn't claim, but there is in the specification.
In prosecution, an examiner can just show a reference that has those wherein, and I think it would be done in that
Yeah,
situation.
I agree with that.
What I'm trying to say, again, this is not my area, but yes, the prosecution only had to show that the prior art results in the same product. What I'm trying to say is that the product is not fully defined, normally, if the claim is right, is not fully defined by the wearing clauses. The product is defined by the combination of the steps and the wearing clauses.
Yes, but you have to show the combination of steps, what additional structural limitations those combinations.
That's why I'm saying.
There's nothing like that in this case, other than the surface markers. They don't say anything more than that.
Those may be the case here, but I'm saying in general, when we talk about product by process, the steps matter, but the steps define the product.
Well, I think during prosecution, and I do a lot of product by process claims. They tend to come up in pharmaceuticals. You see them in crystalline forms, solid state forms of chemical entities, and so you'll define the product by the steps of the crystallization process, and then at the end you can have the X-ray powder diffraction data spectra, the X-ray powder diffraction spectra, and that defines the product you're claiming. I see them in also do a lot of pharmaceuticals, so patches and things like that, and extended release tablets and things like that. So you've got process of making them, and then you've got, okay, it's going to have this release profile, something like that. And from a prosecution perspective, the examiners invariably ignore the steps. An examiner would look at those cell surface marker profile, like Reza was saying, and to me, if I were an examiner, I would have tried to find a mesenchymal stem cell that had this profile and just said, well, it's inherent. I mean, it's a mesenchymal stem cell. It's going to have this, right? You're not going to express NADOG, and it's going to have at least 3 of these other markers. And if you could find that, then you're done. You don't have to worry about the steps. The argument as prosecutors and as, applicants who are using product by process claims, the challenge is always to convince the examiner that the steps lead to a difference in the product itself. That's the key.
Well, I agree with that.
And that's difficult. Very difficult.
I agree with that. I agree with that. And this is good we have this discussion because there's no agreement on that, which is good. I agree with what the last thing you said. It's true that maybe during prosecution, the examiner will only look at if you have additional elements. Of course, then you have the case that I showed you, it's a pure product by process. What do you do then? The examiner has to go and find a prior art which results in the same product based on what they see in the process. But let's go to your case. It's true that the examiner makes it life easier for themselves by just focusing on the additional variant or limitations and then throw it back to the patent applicant. My point is that, yes, the burden will be on patent applicant to show that the extra steps in the product by process do something, add some limitations which are not claimed in the structure. And that's the whole point of product by process claiming. I'm trying to say that here as well, just to say the product was already in the public domain needs an argument by somebody to show what the steps provide, add to the product, and then you have additional limitations. But anyway, maybe we are not exactly...
Well, I mean, I think in some sense, I understand what you're saying, Reza, but the point there is that there was no such evidence in this case that other than the surface markers, the process steps do anything. Otherwise, they would have had it presumably in the specification, or they could have provided it somehow, that you needed to have these additional features. And there was no evidence of that here, that there was these additional features. So in this case, as long as the challengers could find a reference, no matter how it was done, that had resulted in those surface markers, they would have been done. They didn't need to show the steps
Yes.
of the process.
You're right. In this case, that could do it. I don't know about the specifics. This is also not my area of technology. However, I would just say it wouldn't be the end of the story. Probably the burden would shift back to the patentee to show that those steps add some extra properties to the product. So the product is not just what you see in the wherein clause, it's more than that. I would say that would be the burden. But maybe I can just add one more point related to this, but not along the same line, which is why does an applicant usually utilize a product by process claiming? It was a good review for me when I was going through this. Usually, as we said, it's when they cannot recite the product just by its features for some reasons. Maybe it's complicated. Maybe they can't discover its features easily, but they know how to make it, so they use a product by process. Then the other question comes up that wouldn't the process be sufficient then? If the process is novel by itself and you can get that, are you home free and are you done? You don't need the product by process. And there are reasons that's not the case. First of all, why not get both? And they may provide different type of protections for the patent applicant, which we can go through, but it's all out there in the case law study. But that's the point, that there's always benefit to have a product by process claim in addition to the process claim.
And also, I just want to mention that maybe we should do another video on this, that there are differences in this regard between US and Europe in the way
that's very important.
Product by process claims are construed. So
yeah, and how they are invalidated or how they are considered, how the infringement is considered. We said in the US, for invalidation, you just need to show that the prior art provides the same product, no matter what process they use. And in infringement, you have to show both. The patentee show that the infringer is using the same process, getting the same product. And in Europe or other jurisdictions, this could be quite different.
That's correct.
Yeah. Sounds good.
Wonderful.
Well, that's a great topic, and thanks for a great discussion, a heated discussion. It's a lot of fun, and I'm going to drop.
We need it in where we live. We need a bit of heat. It's a bit cold in here.
Yeah, and the music. I hope everybody enjoys it. And if you want to get in contact with the composer, let us know. Shoot us an email, or if you have questions or anything like that, always feel free to get in touch. Well, thanks so much. Have a great day.
Thank you.
Great.
Bye.